Hello and welcome to our fourth Industrial Relations Seminar. Today we are going to talk about the players involved in the industrial relations system. We'll talk about the courts, tribunals and regulators. We'll discuss the creation and involvement of industrial associations with a view to providing you with an understanding of the challenges that face them, the power they wield, and the value they can give you. Finally, we'll look into the situation pertaining to labour hire and how the decisions you make in industrial relations can either reward you immeasurably or cost you dearly. IR in Australia represents the very bedrock of the political system. The two major political parties have their roots and power bases based deeply in industrial relations-based institutions. The Australian Labor Party was established from the collective union movements, with the majority of party politicians coming from the union ranks. Bob Hawke, Paul Keating, Julia Gillard, Simon Crean and Bill Shorten are all a few recent leaders of the federal ALP who had their roots in the union movement. Conversely, the Liberal Party of Australia have their roots in representing small business and industry, with the representatives largely coming from the business sector or legal fraternity. Over the years, a change of government usually results in a change in IR legislation to suit the interests of the ruling party's masters. To that extent, industrial relations is one of the most amended legislative topics in Australia's history. In addition to the ideological battle, industrial relations has in the past been engulfed by a jurisdictional battle as well. The federal government has always had the ability to make laws in respect of companies where activities crossed state lines or had a national presence. However, historically, it was the states that controlled most of the legislative power relating to industrial relations. That changed in 2006 with the Howard government's implementation of the Work Choices legislation, which annexed all IR law-making abilities over Commonwealth registered companies. That power was expanded in 2010 when, following the introduction of the Fair Work Act by the Rudd government, all of the states, except for Western Australia, ceded their right to make laws over sole traders and partnerships to the federal government. The Fair Work Act created a number of new bodies to regulate, advise and arbitrate the new system. In addition to the two major bodies, which we'll discuss in a moment, the Road Transport Remuneration Tribunal was created to deal with matters involving truck drivers, and the Fair Work Building Industry Inspectorate was created to oversee the building and construction industry. However, the two major bodies that were created are the Fair Work Ombudsman and Fair Work Australia, now known as the Fair Work Commission. The Fair Work Commission is the arbiter of the Fair Work system. Its primary function is to hear cases. However, the breadth of those cases is considerable. Every 4 years, the Fair Work Commission hears cases of the modern awards reviews, where parties seek to amend the respective modern awards. Every year, it hears a case to determine whether the minimum wage should be increased. And of course, it is the Fair Work Commission that hears cases of unfair dismissal, bargaining orders, and protected action applications and disputes regarding award or enterprise agreements. Perhaps the most important function of the Fair Work Commission, however, is as the improver of enterprise agreements in accordance with the principles set out in the Fair Work Act, and critically, the interpreter of the Better Off Overall test that each agreement must pass before it can be registered. The Fair Work Commission comprises of a president, several vice presidents, senior deputy presidents, and commissioners who conduct the functions of the commission. The fwc.gov.au website is the place to go to when you need to review an award or enterprise agreement. The Fair Work Ombudsman has numerous functions. It is an advisory service for employers and employees regarding minimum entitlements or award coverage. It is an investigator and auditor when suspected breaches of those entitlements has occurred, and it is a prosecutor when there is a systematic breach of workers' pay and conditions. As an advisor, the Ombudsman's website, fairwork.gov.au, has a number of great tools including a great pay and conditions calculator, a leave calculator, and a number of fact sheets that can assist employers and employees to conduct their affairs. The Federal Court will hear appeals from the Fair Work Commission as well as cases involving adverse action or general protections claims. Common law courts will hear cases involving recovery of underpayment of wages. In the past, the Fair Work Ombudsman had the power to issue these directives. However, this power was removed from them when the Abbott government took office in 2013. Industrial associations have been a part of Australian culture since the early 1800s, when the very first workers' unions were created. Since then, it cannot be disputed that they have ingrained themselves within the fabric of Australian society. At the dawn of federation, industrial associations first became registered entities as enforced arbitration between disputing parties came into effect. Nowadays, there are hundreds of associations representing the interests of employers and employees alike. Under the Fair Work system, industrial association registration is more stringent than ever, following a number of scandals engulfing both unions and employer groups. The Fair Work Registered Organisations Act of 2009 stipulates the conditions upon which an entity is registered and governed. There are currently 109 registered unions in Australia, representing hundreds of thousands of workers. They range from very large unions like the Australian Workers' Union to smaller boutique unions. All unions are collectively represented by the Australian Council of Trade Unions, or ACTU, which represents the greater union movement in consultation with parties such as the federal government. The union's role is to represent their worker members in a range of capacities, from providing advice on employer decisions, to representing employees during bargaining for an enterprise agreement, to representing members who allege they have been unfairly dismissed, to organising protected action activities such as strikes during enterprise agreement discussions. The union movement's power base is its membership, which can be called upon to finance media campaigns, lobby government, and force employee or union beneficial terms in enterprise agreements. The union movement's greatest period occurred just after World War II, when membership was at 64% of the entire workforce. Today, union membership is at 11% and decreasing. Still, unions wield considerable power both collectively at a national level and individually at the workplace level. A number of current union campaigns affect Randstad in a very direct way. These include the Casual Conversion or Security of Employment campaign, which sees casual employees converted to permanent employment upon acquiring a certain tenure of service. This will affect the majority of Randstad's temporary workforce. Another current union campaign concerns labour hire industry regulation, which seeks a registration system for labour hire groups, including Randstad, to comply with strict codes of conduct or face deregistration. Under the Fair Work Act, all employees have a right to choose whether or not to become a member of a union. They have the right to make this decision without the fear of reprisal or intimidation from any other party, including unions, their delegates and officials, and most importantly, Randstad. That said, there is nothing illegal in a fellow worker encouraging an employee to join a union, or a union advertising the benefits of their membership to employees. Fines of up to $52,000 are in place for people who try to intimidate workers into joining or not joining a union. Randstad have a freedom of association policy which is designed to help you navigate the issues associated with employees seeking advice on union membership. Right of entry is possibly the most powerful right accorded to union officials via the Fair Work Act. It allows a union official who is eligible to represent the interests of a worker on site on 24 hours notice, or immediately if he or she believes a breach has occurred, to enter a workplace for the purposes of investigating such potential breach or speaking to said workers at their invitation. You can learn more about the right of entry on Fair Work Commission website. There are a number of suggestions that I would make to you when dealing with a union. The first is to respect the union. Give them space and do not agitate unnecessarily. Call me if you feel the dispute is imminent. Secondly, understand the union. Understand that their primary goal is the preservation and success of the union. Ergo, membership is their most important priority, and they will go to any means in order to achieve that goal. Rather than let the union create salacious lies that drive a workforce apart, look to encourage collaboration with the union and work towards harmonious relations. Remember, A friendly union official is a great source of intel. Thirdly, understand that unions are a political organisation, with results driving promotion through the ranks. Understand that the union's greatest rivals are not the employers, but rather other unions. Understand that true union officials are former members who have moved into the union ranks. They are not lawyers, but rather are truck drivers and construction or manufacturing workers, or boilermakers and electricians. Finally, and most importantly, understand that there is a distrust of labour hire groups amongst unions, even though they all have arrangements with them. You need to show them that Randstad are different. Industry associations are the employer version of the union movement. Industry associations are a collective of employers who group together for common interests. They usually involve both industrial relations activity with unions and political lobbying. Like the ACTU, so too do industry associations have a peak body. The Australian Chamber of Commerce and Industry, or ACI, represent the collective interests of industry association throughout Australia. There are also other groups who represent employer members at this level, including the Australian Industry Group and the Australian Federation of Employers. These groups usually set the agenda for the employer lobbying in industrial relations matters throughout Australia. Industry-specific associations also wield considerable power outside of ACI in their respective industries. These groups also lobby government separate of ACI and represent their members in IR-related matters. These employer associations are a great source of referral for not only potential temp placements, but also for permanent recruitment. These groups include the Master Builders Association, the Australian Hoteliers Association, and other groups. Randstad are a member of an industry association. The Recruitment Consultants Services Association is an industrial association, and together with other recruitment and labour hire companies, Randstad participate in the direction given to RCSA in respective IR matters. Coming up in our next seminar, we'll discuss awards and enterprise agreements.